and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, I'd like to call this meeting to order. For the benefit of people that aren't here tonight, this is a hearing for preliminary consideration of an election protest filed by the Beasley campaign. Our attorney, the county attorney, Bob Hageman, is going to walk us through this, but I first just wanted to introduce the people in the room for those of you that are looking at this on camera. Our entire County Board of Elections is here. Amy Mead, Frank Dunphy, me, Laura Heisey, Charles Ramos, and Mark Barroso. Our attorney is Bob Hageman. Staff, Steve Simos is the deputy director, and Donald Lyerly is our most trusted election assistant. And we have three guests, all from the North Carolina GOP, Philip Thomas, Chase Gaines, and Brian Levesque, and they're behind me. This could be a very brief meeting, and so let me turn it over to you, Bob, to tell us what we're doing.
Thank you, Madam Chair. So you're here for what's called a preliminary consideration of an election protest. And as you all are aware, it's been distributed to you. Sherry Beasley is a candidate for Chief Justice, filed an election protest. The protest involves, I think, about, if not exactly, 90 counties in North Carolina, including Chatham. And I'm going to walk through for you in a little bit more detail the specifics, but if I've counted correctly, there are 18 protests directed at prospective Chatham County voters. It really only involves 15 prospective voters because 3 of the people identified are addressed in more than one category. And we'll walk through that. Your task today is to decide whether or not on the face of the protest there's a sufficient reason to go forward to the next phase under North Carolina law. I use the word preliminary consideration. So this is not a hearing tonight. This is a preliminary consideration for you to decide 3 things. 1, was the protest filed timely? 2, does the protest substantially comply with the form requirements under North Carolina law and forms for protest promulgated by the State Board of Election? And finally, is there probable cause to believe a violation may have occurred? And in this case, that goes to the failure to count any of the votes or possible votes of the 15 individuals that have been identified in the protest with regard to Chatham County. So let me talk a little bit about timeliness because we all thought, staff thought, that we weren't one of the 90 counties. The protest under state law had to be filed within 2 business days of canvassing. And that day came and went without Chatham County receiving a copy of the protest. And Steve can talk about the particulars more specifically than I can, but my understanding is that there were a couple of inquiries made as to when this hearing would be held, and the response was we didn't have a protest. Ultimately, I believe what the protester ascertained was that we didn't have the protest because it was directed to an email address that wasn't working due to the cyber attack that you're all familiar with. And when it was forwarded to an accessible email address, the 24th of November, last Wednesday, the day before Thanksgiving, what was forwarded was the email string that showed that it had been emailed to the email address that we didn't have access to within 2 days. So on the face of the filing, it was sent to an email address timely, but we didn't receive it because that email address was not accessible. Staff has also made an inquiry and determined that despite being notified of the new email address, the State Board of Elections had still posted the email address that we didn't have access to. So on the issue of timeliness, it appears, at least to me, based on the email communication, that there was an attempt to send it to the public, not an attempt, that it was sent to the email address that was listed on the State Board of Election website in a timely fashion. We just didn't get it because the State Board of Elections had not changed the email address to the new one that we could access due to the cyber attack. So question number one, was it timely filed? Question number two, does it substantially comply with the form requirements? And the state has promulgated a form to be used for filing these protests. You all have the actual protest. It is the form. I mean, that is the form that has been filled out. And you need to determine whether it is substantially compliant with the form requirement based on the way it was filled out. And then finally, probable cause to believe a violation may have occurred, in this case, the failure to count any of the votes that have been identified. So let me go back again and say, this is not a hearing. You're not making a determination of the likelihood that any of these claims are valid or will be proven. You're simply to decide, again, timeliness, substantial compliance with the form requirement, and then probable cause that there may have been a violation. I want to read to you a little bit of some guidance that came from the State Board of Elections. This is important because I know Steve has started to look at these actual allegations regarding these particular voters. But what the state says is if your board would need to perform any review of your records or voter documents, including provisional applications, one-stop applications, or absentee container return envelopes, the board must find that there is probable cause to advance to a protest hearing. The analysis would not be appropriate during the preliminary consideration phase, where only the protest filing is to be considered. So again, if you do move this to a hearing, that is in no way indicative of a presumption that there is a violation or a tentative finding that there has been a violation. At the hearing, evidence would be presented. The burden of proof is on the protester, Ms. Beasley, to come forward with evidence to support the allegations and to convince you that there are in fact violations of election law such that one or more of the challenged non-votes should in fact be counted as votes. That would all happen at a hearing under state law. If you don't dismiss this today, would have to be held within 10 business days. Let me pause there to see if there's any questions before I move to briefly describing what I believe are 7 categories of alleged violations. And I'll walk you through and talk about how many potential voters are in each of those categories.
I don't know who to.
That's okay. I'm sorry.
So it's my understanding that if we dismiss at this stage, that the state is going, that the Beasley campaign has, will appeal to the state.
They have the right to.
They have the right to.
Correct.
And it is your opinion that the state will likely find I don't know what the right terminology is, that we should hold a hearing? This seems kind of perfunctory to me.
Yeah, so I have had a conversation with the attorney from the state board, and I posited the question to her. You've got 90 counties, and these threshold questions are really the same questions for each of those 90 counties. And what I said to her is, let me offer a proposition here, which is that if every board decides these questions legally correctly in the sense that our state Supreme Court said, you did that right, you made the right decision, you should really have the same answer in all 90 counties. But I know that's not happening. I'm aware that some counties have dismissed complaints at this stage, others have not. I've seen one order where a county board dismissed some of the allegations, but not others. At some point, I anticipate the State Board of Elections is going to have to harmonize all this. It's a statewide election, and you've got to have sort of the same findings. The State Board does have the ability, if you dismiss it, to remand it back to you and say, you decided wrong, have a hearing.
Okay.
Yeah, I can't predict what's going to happen,
Right.
but we're in this really interesting situation of 90 counties all having to follow the statutory process. And then ultimately, it all has to be harmonized and reconciled in some way.
Okay, thank you.
Anyone else?
I have a question. So I think there are 100 counties in the state.
Correct.
Why just 90? Do we know?
I don't know. And I didn't count in a complaint to 90. I had heard it reported that there were 90 counties that were included. And if you look at the affidavit that includes all the names, I did a quick sort of measuring on my computer screen to see how many different names are spread across all that, and it looks to me roughly 3,500 across the state,
Wow.
something like that. Maybe it's safe to say between 3,000 and 4,000, and you got 18.
3,500 voters.
Well, again, I don't know how many, I realized today that the 18 that are identified as being in Chatham, 3 of those individuals are in more than one, are in 2 categories. So that reduces it to 15 individuals. Same with the state. I roughly eyeballed 3,500. There's no way I'm going in to try to figure out how many of those are in more than one category.
We will see.
And if you do proceed to a hearing, for some of these, as I explained what the allegations are, they're individual fact specific. So you will have to hear evidence. The Beasley protesters will have to produce evidence on an individual basis of why that individual's vote should be counted.
I have a question. What does our staff have to do in preparation for this?
Yeah.
If we were to have the hearing?
So you'll see when I walk through the 7 different categories that impact you,
Mhm.
you'll see that some of it is asking for or may require staff to go back and check records and give you their input and their testimony as to why we did what we did and why we think that's right, or maybe going and looking at it, we were wrong. But again, that input and that analysis is not to be presented to you today. That's part of an evidentiary hearing if we get there.
I guess the good news is that after the count and the recount, we've got our ballot envelopes in pretty good order, and we've got a lot of documentation for just about everything we did. So it probably won't be too hard to do 15 researches if we go that route.
So would you like me to walk through
Yeah.
the 7 categories?
Please.
And again, I pulled these out of a document that covers more than these 7 categories. We don't have a protest regarding potential Chatham County voters in each of those categories, but there are voters in 7 of the categories. And they're broken up into absentee ballot issues and provisional ballot issues. 3 of these categories are under absentee ballot and 4 are under provisional ballots. Under absentee ballots, there's a category that's been labeled as B2. And there are 3 potential votes in that category. That has to do with an allegation regarding ballots that, I take it, that were determined were received, that the vote may not have been cast or was not cast by election day. And the allegation and request is to review the ballot envelopes, claiming that these were all received between November 3rd and November 5th. And the assertion is that it's not plausible that they were not mailed by November 3rd if they were received by November 5th. That's the category, and that's the contention.
Say that one more time.
So, and Steve, correct me if I'm reading this, understanding this wrong. State law required ballots to be postmarked and mailed by election day. Sure. And we don't know, he's not gone back and we're not presenting evidence as to these potential votes, as to what the indicia is. But the claim is that these 3 individuals' ballots were received by November 5th. And the contention is it's not plausible that they would have been received by the 5th if they hadn't been mailed by the 3rd.
Okay, I get it.
Yeah, and I'm not saying all of these were received on the 5th. It says by the 5th, so there may have been some of these received on the 4th. But they're just saying it's not plausible that they had not been mailed on the 3rd if they were received by the 5th.
Gotcha.
And this is section D as in dog,
B2, boy 2.
boy 2.
Page 2.
Okay.
Yep.
on the- yeah.
Thank you.
As I understood it when I was looking it over, it looked like it was a problem with ballot tracks, where maybe the ballots looked like through ballot tracks that they had been, you know, they'd been in the postal system, but then we received them, and I'm wondering whether maybe they didn't get a stamp or something on the envelope, but that's the kind of stuff we'll find out later.
All right, the next category is category C, and there's one potential vote in this category. And the allegation is that the individual self-reported that they had cured a deficiency. Now, I made a note to myself, I don't know the answer to this. Can cures be communicated by email?
They can, email, fax, in person, or
Okay.
by mail.
So I'm totally speculating here. Our email address problem is potentially an issue here that would have to be demonstrated and proven at a hearing.
So it would be up to the Beasley campaign to contact that voter and get evidence perhaps of an email that was an email attempt. That's not something we have to find out from our end.
I mean, Steve will do his research on all of these,
Yeah.
but the burden of proof is on the protester to produce evidence to support the allegation. And again, I'm totally speculating, but given our unique situation with being cyber attacked, and now we know that the State Board of Election had that inaccessible email address, and we still don't have those emails. I think if the voter can produce evidence that shows they sent it to that email address in a timely fashion, that might be something that is persuasive to you. Third category is D. This also has one potential vote, and the allegation is that on, I guess, the online system, it was originally reported as accepted or accepted cured, and it's now showing as rejected. Whether that's true and what the reasons why it might have been changed, Steve will have an answer for you if and when you have a hearing. So those are the three different categories involving 3, 4, 5 potential voters related to absentee ballots. Under the provisionals, we have 4 subcategories. E1 involves 2 prospective voters, one of whom is also in E6. And the protest asserts that the provisional ballot applicants claim that they resided in and are registered. They're claiming that they were registered. Steve may know the answer now, but this is not the time for him to come forward with evidence to respond to that. But that's the factual dispute that will have to be resolved if you go forward with the hearing. The next category is E2. There are 3 potential votes here, 2 of which are in other categories as well. And this category asserts that the individuals attested that they have maintained residence in the county despite having been removed from the registration rolls. E4 is the biggest category. There are 6 potential votes, 2 of which also are in other categories.
What about E3?
There are none under E3.
Okay,
I'm sorry. Yeah, I'm just hitting the ones where they're,
that's fine, I just wanted to keep
Yeah.
up.
On E2, how many voters were there?
E2, there are 3 individuals.
3 people.
Two of whom are listed in other categories.
And could you tell me the number of voters in E4 now?
E4 has 6 potential voters. And the allegation there is that the individual self-reported an attempt to register at the Board of Elections or DMV. And again, the burden is on the protester. And then the final subcategory is E6. There are no E5s. E6, there are 2 potential voters there, one of whom is in another category. And the allegation there is that these voters were required to cast provisional ballots during the one-stop period for reasons other than needing an ID or that or a voter already voted. And the allegation is these voters should have been, and presumably the allegation is they were not, provided an opportunity to register or re-register. As I understand it, in North Carolina, you can register at the time you go to one-stop voting.
That's correct.
And these individuals are allegedly claiming that they were not given the opportunity to register, and presumably the only reason they were required to take a provisional is that they weren't registered.
They claim they were prevented from registering?
It doesn't say they were prevented, it says they weren't afforded the opportunity. And the allegation is that the obligation and the burden was on not the individual to, I'm going to paraphrase here, that the duty was on the election official to inform them and provide them an opportunity to register.
So if I do the math, subtracting out the ones you said were in multiple categories, I only came up with like 12.
So here's how I did the math, and I may be wrong. There were 18 names listed, 3 were in 2 categories. So I subtracted 3 from 18 and came up with 15.
All right, so if you indulge me, please.
Sure.
B2 has 3
Yep.
individuals. C has 1.
Yep.
D has 1. E1 has 1, but that's also in another category.
No, 3.
2 under E1,
Oh, 2 under E1, okay.
with 1 in another category.
Okay. E2 is 3 individuals with 2 in another category.
Correct.
0 E3. E4 is 6 individuals.
With 2 in another category.
P4?
I didn't get that one. Okay, so E5, 0, E6, 2 individuals, 1 in another category.
Correct.
So that gives me.
That's
15.
5, isn't it?
15.
So there are 3 people who are listed in more than one category.
Right, so subtract 3 from that total.
Right. But again, somebody who's listed in more than one category that protest may fail with regard to one of those categories.
Right. I understand.
Neither of them or both.
Right,
Yep.
okay.
So the proof again is on the, who is on the proof again? I'm sorry, I missed that.
So ultimately, to sustain a protest, the burden of proof is on the protester.
Okay,
But that's not the standard for tonight.
right.
So tonight, we're just deciding if
So
we're gonna have a
we,
protest
where
hearing.
do we, as a staff, board members, where do we come in now? Is to decide what?
Tonight, your task is to decide, 1, was the protest timely filed?
Correct.
2, does the protest substantially comply with the form requirements? And then 3, which is kind of what I just walked through right now, is there probable cause that a violation of law may have occurred? And again, that's not a determination that it likely occurred,
Okay.
or that it more likely than not occurred. because you haven't heard the evidence. It's just based on the face of the complaint.
And the evidence will come from our part.
So the evidence
Both sides.
will come, yeah. Anybody with relevant, evidence,
Right.
and that could come in the form of affidavits, testimony under oath before you, documents that can be produced. And then you would examine all that, and then you would decide factually what you believe.
Okay. And we will make the recommendation,
Then you would make a decision.
decision.
Okay, so one more thing, so how this plays out, there's something that's called outcome determinative. Let's say that this was a protest to a candidate, election to the Board of Commissioners. And let's say after all the counting and the recounting, there was a separation of 400 votes. And you received a protest that involved 20 potential votes. Even if those counted, they would not have affected the outcome. You would not go forward with this process because it's not potentially outcome determinative. Now, you may ask, how do 15 votes in Chatham County? Well, we're dealing with a statewide election. You can't decide whether your 15 votes are outcome determinative. So all 90 counties have to go through this process, and then the aggregation of all of that will be looked at by the Board of Elections to determine, State Board of Elections, whether or not this protest is potentially outcome determinative. You're just tasked with dealing with what's in your jurisdiction.
So if there are 10 votes in 90 counties, that's 9, each county with 10 votes that are determined to be erroneous, that's 900 votes we're talking about in aggregate.
Correct. Well,
Yeah,
and
we don't make the
I'll even drive
determination.
this,
No.
I'll drive this point even further home. Let's say that the final vote, I think we're getting close to it, maybe out already, on the recount, let's say it's 400 votes. And let's say that as a result of this process, when it gets to the state board, there are 401 votes in play. That's theoretically outcome determinative. But practically, we all know that it'd be virtually impossible that all those votes would have been cast for one candidate. But by law, if there's 401 valid protests, and there's a 400 vote separation, 401 is outcome determinative.
Okay, well, are we ready to take these three categories of decisions at hand and agree on how we stand on each of them? The first question is, was this protest timely filed? Anybody have any questions about that?
I do.
Comments? Yeah?
So timeliness, we had a deadline that was missed, but you mentioned that the email was displayed on the state website incorrectly, so that the sender would not have known the correct address to send it to. So does that I'm only throw this out, does that, what would that be underneath the law? Is that, did they get a pass because they had bad information and didn't get it to us on time, but then they able to submit late?
In my legal opinion, yes. That the burden of complying, the error was not the protester's error.
Okay.
And you, I think you said you also have the original email where they did meet the deadline, it just went to the wrong address. Is that correct?
The Beasley committee provided that for us.
Yeah.
We verified it, so.
And frankly, that might also be a factor in a hearing. And if there's anybody who has evidence to the contrary, and you can test and probe the truthfulness of the campaign or the protester in terms of did they in fact send it, but the evidence we have right now They forwarded an email, you know how you forward an email, and the original email shows below, and the original email shows it being sent to the email address that was on the State Board of Elections website that we could not access.
So do we have data, do we have objective data that the state board displayed it incorrectly?
Yes, because we contacted the state board. So when we had our cyber incident a couple of months ago, we contacted the state board and told them the new email addresses. They made all the internal changes to make sure they can contact us. Changes were made on our website. The public was notified. There's one spot on the email, there's one spot on the state website which is contact us, and it says contact your local board of elections. If you go on there and you hit Chatham County, it still has our old phone number and our old email address on there. And so once we became aware of that situation, we contacted the state and told them they need to make the corrections on there, and they have since then made the corrections.
So that erroneous display was during the time that they were required to send to us that they took, okay.
Yes.
Yeah.
Should we take this as a motion, a series of motions? Would that be the best way to proceed here?
Sure, I think someone wants to be
Yeah.
recognized behind you.
Sorry.
Madam Chair, and I'm sorry to interrupt. I was
All
just,
right.
I figured this would be the appropriate time before you all started
All right.
your deliberations to inquire whether there was going to be any opportunity.
Introduce yourself, please.
Oh, I'm sorry, Brian Levesque, on behalf of the Newbie Campaign, whether there would be any opportunity for the campaigns themselves to be heard from, the affected candidates, or a public comment period.
No. We've already agreed on it.
Well, no, we've agreed there's no public comment period. I think it's open for discussion. Do we want to hear from the attorneys representing the Newbie campaign or the?
I do not.
campaign? You do not?
No, I think we're getting into a hearing, and I don't want to be weighing evidence, and we're not supposed to be. The four corners of this document is what we're ruling on.
And to be clear, I wasn't suggesting that we would be presenting any evidence or anything along those lines.
Thank you. I still feel that way, that our instructions are clear, that this can devolve very quickly, even on our side. You know, we'll start saying, well, this happened, you know, just don't want to get into that, period. I don't want to even give that opportunity for that to happen.
I'd be willing to listen to a 3-minute presentation
Uh,
from the two.
Chair, I'm sorry, I disagree with you. You can't do an arbitrary limit that you're creating for tonight only, that we've never had a 3-minute limit before. We're creating new rules on the fly here, and that's just not the way to do it.
I also feel like if we're not taking comments virtually, that presentations from parties or campaigns is a comment, and that's, so I mean, if we're not doing it virtually, we're not giving people the opportunity to do that because they didn't show up here, then I just don't feel like it's fair.
Yeah, the public is the public, and they're part of the public.
And I also feel like we're supposed to be deciding on, it's very clear what we're supposed to be doing. We have 3 objectives, and that's, as a board, we need to make that decision.
Comments from either of you guys?
Are we not taking public commentary
No.
over the internet? Okay.
We said in the notice that public would not have a chance to comment. We can't change it now.
No, no.
Okay, well, all I would say is that the attorneys for the campaigns are not just the public. They are representing the campaigns, which are the topic of this hearing. So I think they have a different status than the general public right now.
You may think that, but that's not,
I'm just telling you what I think, okay?
that's fine, but
All right.
I don't think that's, if we're
Can
gonna do that, I
you
would
help
like to
us
have
out
a
at all
vote.
with this?
No, I would like to have a vote if we're gonna start inviting the attorneys to comment.
Could we ask our attorney
That's
to
what
say
I'm
something
gonna
about
ask,
it
yeah.
first?
What the-
I think it's the board's prerogative.
Excuse me?
It's the board's prerogative.
Board's prerogative, okay.
So let me ask a question. Were the Beasley attorneys prohibited from attending this session?
Yeah.
No, everybody got notice, all.
And they chose not to show
No,
up?
no, he's here.
Oh, we have one. Pardon me, I didn't, okay. So we have a Beasley representative here. So, if, Mr. Barroso, if the attorneys talk, we have to give equal time to both. If we don't, no, I hear you.
I know, we're just making stuff up.
Okay.
It's not appropriate to make stuff up that, oh, I'm curious, let's change the rules so we can satisfy our curiosity. I'm not a fan of changing the rules.
Chuck, what's your feeling about this?
I'm waiting for anybody else to finish.
I think everybody else has had their say. If you, or, well, actually, have you?
Well, I think Mr. Barroso has a good point. Our agenda tonight was to deal with the four corners, as Mark Barroso suggests. Did we have any open, can we change as we go, as he is opposed? What was our agenda tonight?
Our agenda is to deal with this preliminary hearing. That could include, as our attorney has just said, it could include listening to the attorneys representing the campaigns, or it could not include that. It's not that we're changing any rules, we just haven't,
Procedures.
procedures. I mean,
Yeah,
it's
I'm
not
not gonna-
uncalled for to ask the attorneys to speak. I'm fine. If you don't want to hear from the attorneys, that's fine. But, it's not like we're rule breaking to ask them to speak,
Okay, well,
or invite them to speak.
change the procedures then. Whatever terminology you want to use. So
So-
I'm done.
Let me ask, what's our plan for moving forward? If we decide tonight to move to the 10-day window, then move to the next step, then that's when legal guys will roll up their sleeves and be pointing out their opinions
Yes.
at that point. And what's the disadvantage of not listening to both sides tonight and moving forward? And what's the disadvantage of listening to both sides for 3 minutes each and then moving forward? We want this information from both sides. We have representatives.
I feel like it would muddy the waters for what we're here to do, to hear from outside counsel. This, to me, is something that's very clearly supposed to be a board decision, and based on kind of the five of us, with counsel from our county attorney. So I think that's where I am with it. I mean,
Okay.
these folks are gonna be here to present information if we decide to have a hearing, at another time. So. that's-
Madam Chair, if I could clarify that request.
Sure.
And again, nothing to do with the evidence, nothing to do with talking about even the substance. I did have one comment that I'm quite confident I could keep under 3 minutes that really just had to do with the statutory procedure for how this works. Nothing to do with the protest itself, so.
Are you guys
That was-
good with hearing that?
That would mean we'll need somebody else,
Yeah,
so it'll be 3 minutes, 3 minutes.
If we listen to one, we have to listen to the opposition.
I agree with that.
are you prepared to speak for 3 minutes this evening?
I would like a vote on this for the record.
Well, I agree with you on the vote. I'm just asking if the Beasley campaign representative is available, is ready to speak for 3 minutes if we're going to, if this proceeds. Sir?
I came primarily to observe, and
Okay.
not to engage in a legal argument. You have counsel to advise you as to what the law is.
Then
I would have a couple of comments that I think might be helpful, but I'm not asking to be heard.
okay. I think that it's pretty clear.
Sounds like we need to take a vote.
Mhm.
Okay.
Somebody needs to make a motion.
I was just gonna ask all in favor of hearing from each of the attorneys, or one attorney from each side for a maximum of 3 minutes each. Raise your hands. Opposed? Okay. Maybe we should have the decent man speak first.
All right. He's the one who requested.
But you're initiating the.
That's correct.
protest.
First of all, my name's Wade Barber. It's a pleasure to be here. This protest was filed, as has been indicated, statewide, and the Beasley campaign put on a tremendous effort to carefully review all the ballots in North Carolina, all the voters in North Carolina. We had how many cast here? 30,000?
48,000.
48,000 cast here. There are only 15 voters who we think we need to review and are asking you to review for a protest. And as to the legality of it, the law was carefully done, this petition was carefully done. There may be a difference between us as to whether it meets the standard or not. If you find that it doesn't meet the standard, then the process is an appeal to the state elections board, and then if they find it does meet the standard, then it comes back to you to have the hearing. If you grant this, that means there are 15 voters that will look like, you said, for 10 days from now. The Beasley campaign will come in and work with the staff, and some of these factual things will become apparent. And the Beasley, when it becomes apparent to the Beasley campaign that although there was probable cause to question them, that the facts are otherwise, then those will be withdrawn, and it will be resolved for everyone. And then it will be whittled down to fewer than 15 to question then, but everyone will have the opportunity then to get into those facts and determine the facts, and it's a factual based thing, and I respectfully hope that you will give the Beasley campaign the opportunity in Chatham County to ask you to review and make a determination on additional evidence as to which way the facts carry.
Thank you.
Yes, ma'am. Again, Brad Lenecki on behalf of Justice Newby. And nothing as to the substance of the protest or whether there's probable cause or anything along those lines, but I did want to clear up just one quick thing about timeliness, because that is one of the things you have to decide tonight. And I did hear your county attorney explain that, you know, if it's filed within 2 days of the canvass, then it's timely. I'm not sure that that's exactly correct in every case, because if a protest, there's actually 2 deadlines. One is prior to canvass, and one is 2 days after canvass. And the reason for those 2 different deadlines is what is the nature of the protest itself. This protest, on the form that's been prescribed by the state board, there's a place for you to check boxes, and you can indicate what your protest is about. In this instance, both boxes are checked. And they say, it's a protest about the manner in which votes were counted or tabulated, check. And then there's another place that says there's an irregularity, misconduct, or fraud, essentially, and that's checked. That becomes an interesting question when you consider those 2 distinct deadlines. There's a deadline. If your protest concerns the manner in which ballots were counted, you have to file it prior to canvass. If it has to do with an irregularity or fraud or a violation of election law, you get that extra 2 days after canvass. I don't think there's any question, especially when you read the protest itself, where in nearly every category ends with a sentence, something along the lines of, these ballots should be counted.
Sir?
Those would be,
You're
ma'am?
muddying the waters.
I'm sorry?
You're muddying the waters.
I'm sorry, ma'am, I've got 3 minutes. Thank you.
This is written by our county attorney, the one you're talking, the document written by our attorney?
No, he's talking about
No,
the
sir, I'm talking about
protest.
the actual protest. Where within the protest itself, says, at the conclusion of almost every section, these ballots therefore should be counted. These voters' ballots must be counted. Counted, counted, counted. This protest deals with the manner in which votes are counted It should have been filed prior to canvass, according to statute. And that statute, for your benefit, is 163-182.9B4. Sets out the timing for filing a protest shall be as follows. And there's some things there that you can review, but I think it would be our contention that it's not timely for that reason, and all the email issues and stuff notwithstanding, we would agree that, and stipulate that, yes, it was received within the 2 days. We just say that that's too late. Thank you.
Thank you.
Yes, sir.
Looking at the protest form, I'm not even finding the part about when it was filed. Maybe I've lost track of the page.
When it was filed, or what box is it on?
What is the, what's the timeliness? Where is the problem?
Please observe social distancing, sir.
If you look, I think.
Oh, it's dated.
Yeah, top of that, well, the back of the first page, at the top, it's number 5, which is where I was talking about those boxes being checked about what kind of protest it is.
Is our attorney has any comments about this?
Yeah.
So, let me reiterate what I understand to be the argument, to make sure we're all clear. So he correctly identified the relevant statute and quoted from it, 163-182.9B4, and it does address timing for different kinds of protests. And subsection B says, if the protest concerns the manner in which votes were counted or results tabulated, the manner, which sounds to me like a verb, and the protest states good cause must be filed until 5 p.m. on the second business day after the Board of Elections has completed its canvass. That's one of the subsections you're citing, right?
Are you asking me some?
Yeah, I want to make sure that I'm understanding your argument correctly.
Well, it's all of those. I mean, it sets forth initially, if it's, dealing with this, it's this deadline. If it's dealing with this, it's this deadline. And then I think the provision that you're looking at there, I think it's number 4, says even if you miss that deadline, but you show good cause why, then you get those 2 days as well. And our argument would be that there's nothing in the protest itself setting forth good cause for the delay.
I guess here's what I'm struggling with. I'm looking at 163-182.9B4, right? And I'm looking at subsection B and C.
Is this on one of our documents?
Let me make, I'm
I just want to read along.
Yeah, no, you don't
No,
have
it's
it.
in our-
Okay.
It's state law.
That's fine.
It's state law.
It's in our law books.
Okay.
I want to make sure I understand what provisions he's pointing to before I advise you.
I think you'd be looking at 163-182.9B4. The timing for filing a protest shall be as follows, and you've got A, B, C, and D.
Correct.
I think the ones that would be implicated here would be A
I understand what you're saying.
or B.
Got it.
Or C.
B picks up the good cause shown.
Correct.
Got it.
Yes,
Got
sir.
it. Okay.
What is good cause? What does that mean? Good cause for delay. Good cause for delay, does that mean displaying an erroneous webpage email address? Is that?
No, I think he is conceding that if the standard was 2 days after canvassing, that sending it to the wrong email address is not fatal. I think he stipulated to that.
Yeah, that's correct. Just
Correct.
that it's not the 2-day limit that would apply. It would be
Correct.
the prior to canvass limit that would apply.
Correct. What he's saying is, so unless there's good cause shown for why you delayed, and in this case, that would not have been a problem. The question is, what's the standard for when you have to file the protest? And he is asserting that the standard is it must be filed before the beginning of the canvassing meeting, if the protest concerns the manner in which votes were counted or results tabulated. It's a verb. The manner, it's a process challenge. And then subsection C, if the protest concerns an irregularity other than the vote counting or result tabulation, that gives you the 2 days by 5 p.m., 2 days after completing canvass. So the question is, are these protests based on the manner in which votes were counted and results tabulated, or is it for some other reason? And Madam Chair, since you did not have the benefit of hearing the argument, I'd encourage you to at least give an opportunity to Mr. Barber to respond to that assertion.
All right, not expecting to make a legal argument, I didn't even bring the statute up.
This is exactly what I'm talking about.
Yeah, this is
This
money in the
is
bar.
exactly what I was talking about. The other side is not prepared, he came prepared. He didn't tell him to get prepared. This is
supposed to be a
The
meeting.
question is whether the protest is timely. That's a legal issue that we're supposed to be fully informed about before we make a decision. So we're doing the best we can, right?
no. Please proceed, Mr. Barber.
All right, let me read what he was saying. I did not realize timeliness would be an issue.
Let's take that.
I think we've blown through the time limits anyway, so go ahead.
All right.
I have something to say while we're waiting on Mr. Barber. And this has to do with the provisional votes, or provisional ballots. Since most counties in North Carolina would have done their provisional ballots and supplemental absentees that day before canvass, I kind of feel like this is disingenuous on the newbie campaign. And I'm not saying that because I feel like as far as timeliness is concerned, that.
That there's no way you could have a protest before those votes, the provisions have been dealt with.
Exactly, and as such, I really feel like that we're having something of a forked-tongue conversation and money in the waters. As far as timeliness is concerned, based on what our county attorney and the email chain, which I have right here on my phone, and I'm sure you have as well, access to, very clearly states November 17th. So, you know, Mr. Barber, if you'd like to speak, that's fine, I just had that to say. And then after that, can we have no more outside comments? Okay, thank you.
I think a lot of these protests don't involve counting the votes or how you go about counting the votes, but it's a question of determination of whether it was an absentee was allowed or not allowed, and that kind of thing, first of all. And secondly, if it comes into that category, you can see that here, they had to evaluate, go through 30,000 folks in Chatham County voting, and go through and winnow that down if they weren't going to do a frivolous application, and narrowing that down to 15 on its face shows that it was not frivolous. And narrowing that down takes time. And so I think even if these complaints fall into the manner in which you counted them, that it shows that the delay, the time was reasonable in that. But I'm not conceding that these protests come out with the manner in which you count them.
I agree with that. When I was reading the part about manner, it seems to me that's sort of open to argument about what you mean by that. If it just means, you know, are you putting them in the tabulator in a certain way versus all the decisions that we make about looking at the absentee ballot envelope or the research that goes into how the provisionals are dealt with. I mean, all those kinds of things are very different than just the physical act of how we handle the ballot when we put it into the container. And so I'm not convinced that we have a timeliness problem here at all. It looks to me like we're fine.
Yeah.
Is there any more discussion about that, or can we just go ahead and have a vote on timeliness? Do you have a motion?
I'll make a motion to vote on timeliness.
Okay, so what is your motion?
My motion is that we vote to accept these as being timely.
Second?
Second.
All in favor? Opposed? Timeliness is dealt with. I can't read my writing. The second one has to do with,
Whether or not the form was filled out correctly?
Yeah.
Substantially complies.
does anybody have any comments about that, or can we move to a motion?
I do.
Okay, Frank.
So I'm looking at the book here on page 213 about filling out election protest form. No. There's no mention of a form. It just says the protest shall be in writing and shall have the name, address, telephone number of the protester. That's easily. And they have to be a candidate or a registered voter. She's a candidate. So why are we getting bogging down forms when they say they just need to have their name, address, and they need to be a candidate in the jurisdiction? Is there something special about the form? I mean, this is I'm reading out of the law book here. That's on page 213.
Yeah, I don't have that actual book. I don't know if that's current. Perhaps it is, but I don't think so.
It says election-related laws in North Carolina 2019 edition. So I'm just saying, what's the big deal about a form when it just says
Well,
name and address?
I expect that that's part of the inner workings of the State Board of Elections. If you go to the administrative code on page 428, they're talking about timely receipt of an election protest. There is a state form, and that's what this is. And so they have filled out the form as the state is requiring it to be filled out. I mean, they have used the state form to fill out their protest.
Well, the reason I say it's because it looked like this was number 2 on the list. It had to be compliance with the form. And if she gives her name and address and phone number, according to the law, it's not a big deal. But to the state board, it's a big deal.
Well, I guess if they use the right form, because it says it right up here, using form.
And they don't want a frivolous protest where somebody just puts their name and address on it and says there were problems. I mean, so they have the form and they have the things you have to fill out. Any other comment about
The form?
whether the form was well filled out? Can we have a motion about
So I
that?
might add, the form looked like everything was there that was
Yeah.
required by law, but I didn't know if there was something else.
Do you want to make a motion?
Oh, yeah, the form looks good to me.
Second? Amy, all in favor? Opposed? And the final one was whether we think, maybe you could restate the final thing that we have to agree to, Mr. Hickman.
Yes. Determination of whether the form, the protest document itself establishes probable cause to believe that a violation of election law or irregularity or misconduct has occurred. And again, that probable cause doesn't mean that it's more likely than not, or that the evidence suggests that it does. It's sort of a minimum bar that needs to be cleared to justify going further to actually have a presentation of evidence. And that if you make this determination, it is in no way a predisposition to an outcome.
It's really just saying this is worth looking into.
Correct.
Any further discussion about that?
I'm
Any
gonna,
discussion at all?
yes, I'm gonna, say that, I'm being asked to make a vote on what I consider incomplete information. There's no way I can make a decision on whether, 3 ballots were returned after a deadline or before a deadline until we mine through our records.
Well,
That's the point.
That's the point.
I know, and and then the other one is witness information, and then, no record of registration. Steve, you haven't mined through this data yet, right?
he's not allowed to.
I'm not.
Well, then we can't, then that means we have to, do the next
Probable.
step, we have to do the next, because I can't make an intelligent
Right,
decision with no data.
I agree with you, Frank, and yeah, I think this is analogous, please forgive me if I'm not going too far out on a limb here, but it's kind of like a grand jury where they say, we think this guy committed a crime, let's have everybody stay in court, and I'm a fan of it, giving everybody a day in court, present your case, thumbs up or down. So I think that there's enough smoke here to see what the result is, and both sides will get a chance to make their case.
Yeah, and the thing that I just want to throw out on the table is, we've got someone sitting at this table who's excellent at mining through that. I'm talking about Steve Simos here and Ms. Pascal. And, but we have no data to make decisions on. This is
Right.
important stuff.
Sure.
I mean, so I'm gonna have to vote, when we do vote, we're moving forward to get accurate information, I'm afraid.
Okay.
I don't wanna do it, but I'm gonna have to.
Yeah.
Anybody else have any comments about that, the final question here? And if not, does somebody want to make a motion?
Okay.
Charles?
I make the motion.
And I'll second.
What's
The
your motion, Frank?
Yeah.
What's the motion, Charles?
Frank.
Keep this,
To move,
To
Oh.
move
The
forward.
motion is to move
to
forward.
get, let Steve mine through the data and find out.
go to the office and look into it.
So I might add that, what we're talking about, what Chuck just proposed is to let Mr. Simos mine through the data on these 15 cases, and he's very good at what he does. And I
I'm not
suspect,
the one that's gonna be, it's not just gonna be me that's doing this.
I
It's gonna be
know.
the whole staff in our offices.
he has a well-trained staff, and I have no doubt we'll resolve most of the, if not all 15, there will be 14 resolved, and one maybe be muddy water, but
Well, so the actual thing we need to be saying in this motion is that we do find probable cause to move to a full hearing, protest.
Yes.
So, with that, do you agree that that's the motion? Do we have a second?
Yes.
Amy, all in favor?
All right.
Okay, there we go. So the next step is to figure out when we're gonna have this, and what else do we need to decide tonight?
So
That's
that's-
it?
what kind of time interval?
We have 10 business days.
10 business days from today.
That's like 5 days a
Steve, you
week?
had a suggestion about when to do this, and you've already done some preliminary,
Next Thursday would be,
next Thursday?
yeah, my recommendation is either next Thursday or Friday, but some people are, may not be available.
The big room over there is available for this.
And I would prefer it not to be done, I know all of our board meetings usually start at 5:30, but I prefer for that not to be done, since we're gonna be going through 15 of these voters and evidence to be presented. I prefer that we either start in the morning or at least after lunch, so we can get through and end by 5 o'clock business day.
Does, how are board schedules for this?
Yeah, Thursday is, I have meetings all day on Thursday, but I'm free all day Friday.
Anybody else? Is Friday, a week from tomorrow? Does that work for people?
Friday, the what? What is the date of Friday you're talking about?
That's
Friday the 11th.
Friday the 11th.
I'll go on Friday.
You want Friday?
Mark, can you
Yeah,
make it?
Let's get this over with.
I agree with that.
Yeah, and
Uh,
if you think it's gonna take all day, then let's start.
I'll make it a point to be available What time Friday are we talking about?
Let me ask a question. I like Friday, but wait a minute. What's the agenda gonna be? Are these guys gonna be duking it out and counterpoint, and so what? I mean,
We will
is this
do
gonna
our
be a long,
research.
drawn-out thing?
We will do our research on our end here, on these 15 voters.
Can you get it done in a week?
Yes,
Answer yes.
definitely.
So-
And the committees will present
So-
their evidence.
Yes.
If I could weigh in, I think I heard, and it makes perfect sense from Mr. Barber, that they're gonna do their homework with staff, and it may be some of these fall away.
We expect to.
So-
What does that
so-
mean?
Well, based on what staff does and further investigation, the Beasley campaign may conclude that they're gonna lose on this issue. And
Or
they
that
may.
some of them will lose.
Some, yeah,
Yeah.
and it's possible. So your high end are 18 different challenges involving 15 different voters, but between now and then, that number's not gonna go up. It may come down. And then both sides will know what is at issue when they come into the room. And presumably will be prepared to offer evidence. Staff will offer evidence based on the research that is being done. There'll be a chance to examine witnesses and then make argument on both sides. And my recommendation, I'm happy to be in communication with both sides ahead of time to kind of coordinate to make this as efficient as possible and have a game plan. But we may all decide, let's deal with this category first. Get all the evidence in that category, let you make a decision. Move on to the next one. Let's, instead of throwing it all out there and then having you at the end trying to sort it through based on the different categories. But between Steve and I, in communication hopefully with two campaigns, we can make this as efficient and painless for you as possible.
Question. So on that line, would it be out of line to ask you to kind of, I'm not trying to usurp your authority, but kind of run the show, like we're gonna do this first, this second, this third, this fourth?
I'm happy to be in communication with the chair before then to make sure we have a game plan and understand who's going to take what role.
Because I agree with the efficiency part.
Can I ask a question on that? We're gonna be coordinating with the committees. If we find, you know, they've got their research, we've got our research, and we talk amongst the committees, we find that there's no basis or, you know, these voters, is this something that we're still gonna bring up in the meeting? Or do we say, all right, out of the 15, we only had 3 that we need to talk about, the rest of
So
them?
I could see several possibilities, maybe all of this will happen. The Beasley campaign may be convinced that they don't have a valid claim with respect to X, Y, and Z, and they may say, we're dropping those. Okay? It may be that, based on Steve's research, he concludes, this one should have counted, right? Now, you still need to make a decision. He's not gonna make that determination, you do, because it's in your hands as a protest, but it may essentially be stipulated going in, where staff comes in and said, here's what we found based on our research, and the parties may have nothing more to say. And then there may be some where there's a genuine factual dispute where evidence has to be presented and legal arguments made as to whether this vote should count or it should not count. What I'm saying is that we will do the best we can between now and when you have that hearing to have sorted all that out and hopefully make this as efficient and clear with the minimum amount of confusion and conflating of issues that need to be separated.
So, what if we don't finish Friday? Then what do we do?
You will continue the meeting to a time when you can reconvene.
We reconvene again.
And then keep working until you're finished. Be glad you're not Wake County or Mecklenburg County.
How many do they have?
Hundreds.
More than us.
Wow.
More than that.
So, as I read it, this is supposed to be a quasi-judicial hearing, and I'm not sure the board knows exactly how that works and how it's different than a regular board meeting.
So quasi means sort of like a court proceeding, a judicial proceeding. You will make findings of fact where there's disputed fact, and you will make conclusions of law, and this has to all be, it's my task, my job to help you through that, get instruction and write the document, but at the end of the process, there'll be a written decision that for those matters in dispute include findings of fact, what are the facts, and then you apply the law to that, to what is the conclusion, which in this case is going to be this vote should count or this vote should not count. And that's why we need to be really orderly in terms of dealing with each category, and then within that category, each prospective voter, so that we have addressed each disputed vote in a way that's legally defensible.
Question on that. Does it have to be, when they're making, when the board's making a decision, does it need to be a unanimous decision on every one of those, or just?
Every time you take a vote, a majority controls that vote. There's no unanimous requirement for each one of them. There will be a court reporter, and witnesses will testify under oath, and they're subject to cross-examination. And as I said, other evidence, including affidavits in the courtroom. Affidavits are not favored, but there are circumstances when they can be admitted in a trial. They can be admitted in a quasi-judicial proceeding. So you may have sworn written statements from people, and they may not appear here personally to testify.
So if we say all 15 of these voters come to I mean, we have to deal with all 15. We're gonna have 15 written decisions, one on each of the,
I foresee it going into one final decision, but it'll go through each of the protested votes that are still in dispute at that point. And,
yeah, but you're not gonna have 15, maybe we might find 3 of them valid and 12 of them not valid, or
That's
half and a
correct.
half.
That's correct.
So we're gonna have,
But that's all part of the decision.
yeah. There's nothing that says that all of these are valid or none of them are valid. They're categorically separate, and they're fact-specific in many cases.
I think you guys are talking past each other. Yes, we're gonna rule on each one,
okay.
but in the end, the writing is gonna be one decision. We decided 12 are valid, 3 are not.
That's right.
Oh, I see, okay. A summary comment,
Yeah.
okay.
So who swears the witnesses?
As the chair, you will administer the oath. I will have a document to help you say the
Okay.
magic words.
Okay.
And who does the cross-examination?
I do.
Yes, you as board members can ask questions of witnesses.
Okay.
And then the attorneys may question witnesses.
And is there an orderly procedure for that?
We will try to create one and try
Okay.
to adhere to it.
Okay.
It might be a cage match.
All right.
Interesting.
So,
Is everybody good for
I
Friday?
have a suggestion.
Friday.
I suggest if we do it Friday, we get a morning start, because we don't know how long it's gonna last.
Okay.
Yeah, I agree with that.
What time on Friday?
What works for you?
What, 9 or 10?
9 or 10 works for me, whatever works. Like I said,
10.
sooner we start.
Should we say 10?
10.
Does that work for you?
Yes.
Yes.
10 a.m.
What about
Friday.
you? Does that work for our videographer?
And it's in this building.
It'll be in this building, but it won't be in this room. It'll be in the big room to accommodate for social distancing and having more people in the hearing than we have today.
Are we required to send out a formal?
We'll take care of that.
Yeah, we'll take care of all that. We're going to contact the committees and the lawyers and all that stuff.
Very good.
Any other questions, or are we good?
Sure, everybody's agreed to that time and date. Everybody, the whole board agreed, time and date works.
10 a.m. next Friday. And we've all agreed we can make it.
December 11th. Yes.
Yeah.
Motion to adjourn?
I have one other quick question.
Yes.
At what point do we deal with this hand recount? Is that, I know it's a separate matter.
That'll be sometime next week.
All right, you'll find it.
We'll let the board know when we get what precinct we're supposed to do and
Okay.
when we're gonna get the teams together, so we'll notify the board on that.
That answers my question.
It won't be on Friday. I can tell you that much.
And for that, we won't need the entire board if a few people have problems with it.
right
Yeah, I
next
mean,
to the forum.
It'll be like the.
yeah, the whole board can be there, we can just time it where,
We've got a quorum.
because we're gonna have to hold it in our office and the whole board meeting room,
Oh.
because we don't have the F-suite anymore. So,
We can't, yeah, we don't want to do it.
we don't wanna do it here because that involves transporting the ballots from our office all the way over here, and we're not comfortable with that, so.
So we'll have to, a video, we'll have to have a
We'll
live stream.
we'll tell him when he needs to come, so it'll be,
So really, as, we can't have a whole board there, if we've got a team of 4 and Aaron, and we're supposed to keep it under 10 people or whatever.
Well, I don't know how we tell board members they can't come.
well, I'm not saying the board members can't come, it's just that not all of y'all are gonna be in that room all at one time, so if you come into the
Well,
office,
we
you may
can,
be
we
in
can watch it
Pandora's.
on.
Yeah,
Yeah, you
no.
can be in Pandora's office, and then we can alternate back and forth going into the room.
Steve, I could also start the stream and walk out
Okay.
if need be.
Yeah.
Okay.
Can we also do the physical counting instead of staff? The last time we did, I watched the hand, you had 2 volunteers from each party sitting across from each other, and they were going,
Yes.
doing that.
Tally.
Can't we do that?
Have you ever done that before?
It looks like fun.
No. No.
If we want to, I mean, I'm not saying we have to.
I
but
think
wait a
first
minute.
state guidance, since the board makes decisions on things, that the board is technically not supposed to be
Yeah.
handling ballots and doing all that, since if there's a decision to do that.
We don't want to do that?
We don't want to do that, we need to be there to.
I defer to her.
Wait a minute, I'm gonna make a suggestion, why do we have to meet in office? Why don't we meet here in one of these big rooms? And then everybody can
Because-
participate.
Because
Just say he doesn't
we're
wanna
not
bring the
comfortable
ballots over here.
transporting the ballots all the way from the office to here and then back again to the office. The ballots have been locked in a locked room since the election day, and we prefer to keep them at our office there.
For security.
For
Yes.
security purposes, yes. We didn't have a problem with the Fs because we were just walking right next to it, so.
But if we had a sheriff's escort,
Yeah, I'm gonna I think that, if all 5 board members wanna be there, they should be there. And we need to make room for them. So, we shouldn't, anyway, that's my opinion.
I agree with Frank.
Well, let's see what day it's gonna be.
Right. We'll jump off that bridge when we need to.
Yeah, that's a different bridge than this bridge.
Okay, anything else?
No,
Motion to adjourn?
motion.
All in favor?
All right.
Thanks, everybody.
Thank you.
Who's second that one?
Thanks, sir.